what law schools are doing to try to combat this, and I haven't read that one. But it's like, shoot, you know,
Yeah.
because especially if you're not a top law school, I mean, you need to have students passing the bar exam, right? Otherwise, nobody's going to go to your school. It's going to make everything worse.
You remember what the passing rate for the bar was this year? Like 20s, right?
Don't stand on that. I'm talking about cats.
Oh. Oh my god.
Wasn't the one?
Like 22%, wasn't it? For like
I thought the one-
February?
July.
Oh, the July one sounds like one of the lowest pass rates.
Yeah.
Especially for a July bar.
What do we have to I can't remember.
Dude.
I'm pretty sure we got it.
One was the two editors. One was the one that was like a informant.
Okay. On our final last semester, which subject did we have 2 questions in rules and evidence?
Yeah.
One was like there were just 2 weird questions. I didn't remember. I didn't. We should make sure. You should ask to look at the files.
Can you see my finals?
Yeah, I mean you can, right? You're here all the time.
I know for one, it was definitely one zip pro. Because my grade was atrocious. And then it was the one that we were pissed off. I was like, "Oh, this is the one."
I had a late meeting.
Oh, you did?
Yeah, so I knew I wouldn't make it on time.
You just had?
That we were upset about? No. It was the final.
Oh, it was the final. It was the easement covenants.
Well, they're walking on.
Not videos.
Yes, right. Yeah.
They're walking all the way through.
Yeah.
No, it's one.
Thank you.
Oh, what do you think? You're gonna go to class now? Is that what the deal is?
Yeah.
Okay. Daniel,
Wow, good.
sorry, we're not gonna get you, we're not gonna get credit in time for you to go over. Tough luck.
That's all right. You have a better student.
Well, you know what? Did I tell you that my friend is a big time judge back there?
Irene had mentioned it actually.
Well,
Big time judge.
Dr.
Not just one of those judges, but a big time judge.
So he probably could write you a letter to talk to the federal status and approve people from non-accredited schools.
Right. Well, you told me about that article,
Can
and
you find it?
well, okay. So when I first started law school, I found that case, and I had forgotten that it was Concord Law School. But the guy ends up suing the county for it because he got rejected twice. He got rejected by the state bar, and then petitioned it, got rejected again. So he had to sue the county for it, and the court overruled it, so he could sit for the bar.
Right.
And he was from California too, had passed the California bar.
So will you be going back there anytime this year?
This year, yeah. I'm going back.
Well, I'll set you up with my guy, Mr. Fishman, Kenneth J. Fishman, the guy who the courtroom's been out there. He's a pretty big time.
Well,
He used to be a bigger time lawyer before he was a judge.
The Massachusetts state bar requirements are that you have to graduate from an ABA school, or if you don't, you can get a sponsor, you can petition to take it, but you have to be practicing for 5 years.
5 years.
5 years and be in good standing.
Now, I think that's pretty standard for states that don't have reciprocity.
Right.
So, we'll see. Maybe Fishman can help you. I'll definitely hook you up with him and let you talk to him.
Cool.
Nothing else is a good guy to know back there.
Yeah, that would be awesome.
He was F. Lee Bailey's partner.
Yeah,
The guy that did all the actual.
then you probably ought to know what he's doing.
I would like to.
I tell you, when I was thinking about going to law school, I bought a couple of F. Lee Bailey's books, For the Defense,
Defense
and
Never
Defense
Rests.
Never Rests, and I read those,
Yeah.
and I'm like, yeah, I'm gonna be one of
I
those
gotta do
guys.
that.
And so I never did do criminal defense,
Yeah.
but it was inspiring. I also got a book, The Best Defense by Alan Dershowitz,
Right.
and my mother gave that one to me actually,
Mhm.
and man, it's inspiring.
It is.
The funny thing was, I read Bailey's book about the Carl
Coupling of, yeah.
right, and then I read Morton Halpern's book. He was a medical examiner from New York who testified. It's like they're not talking about the same
Yeah,
case.
exactly.
It's so funny because Bailey's like Halpern's a hack and he's full of shit and all this pages and pages of all this. Halpern, it's a completely different story. It's almost like it's a different case.
It was interesting to see all those famous cases. It's sort of old news now for law students, but at the time it was a big deal. I remember.
Oh, that Sam Shepard case?
Oh yeah.
Oh my God, that's a huge precedent-setting case.
The fugitive.
Yeah.
That is.
But real life, absolutely, man. He comes home and his wife is killed.
Yeah. Yeah.
And horrible pretrial publicity. Judge totally didn't handle it right. And even the United States Supreme Court said, "Oh, come on."
Yeah. Cannot. Yeah, no, that's it. Fishman did all. Bailey and Fishman became the sort of the book surgeon.
Yeah.
Fishman did all the writing.
Yeah.
And Bailey was a very smart guy.
Yeah.
Honest to God, he was a very smart guy in trial, but it was a trick. And I was like, this is great. Yeah.
Oh, really?
And Bailey had a very interesting life. I mean, he had been a Marine Corps pilot.
Oh yeah, and he was a JAG officer, and they did all the polygraph stuff.
Yeah.
Because UMCJ allows for it.
Right.
So that's why.
So he was an expert at that.
He was the expert. And that Tobin guy that he studied with. So he was the dude. And they worked real hard to get him admitted, and they never did.
Yeah.
But it taught me a lot about the polygraph. I learned a lot about it. And I still to this day use it if a guy says, "I didn't do it. They got the wrong guy." I say, "Fantastic. We're gonna come to the polygraph. We're gonna get the results. We're gonna take it to the DA. We're gonna get your case dismissed."
Or not.
Well, and then you say, "Didn't come out exactly the way we wanted."
Yeah.
But okay, we're gonna do the best we can. Nobody knows but us.
Yeah.
But now I know.
Yeah.
Makes me better.
Yeah.
Makes me feel better. Yeah. So it was great stuff. So well, I'll look you up at the fish.
Mid-June is when I'm going back.
Yeah, for sure. I'll send it email.
My goal, I want to be able to take the California bar and then take the Massachusetts bar as soon as possible.
Yeah, while you're still in the
Exactly.
frame of mind.
I don't want to have to wait
Did you ever meet
5 years.
Nicole?
and
Nicole Ebar?
then-
Yeah, I
Yeah,
back and visited him and he took her around. He's now, well, he was in the Dedham, whatever courthouse Sacco and Vanzetti was tried in.
Oh, yeah.
That's where he was when she went back to visit him.
And that case was a while.
Oh, yeah, a long time, like the 1920s or something.
Yeah.
So anyway, I'll set you up.
all right, sounds
All right,
great.
you guys. This is my favorite class. Have fun.
I thought the class that you taught was your favorite class.
No,
Oh, no, you used to teach this. Yes.
If you're a
That's
trial
right.
lawyer, evidence you have to like.
Evidence is everything.
Evidence means nothing until you actually sit in the trial and then you go, oh,
That is very true.
That's what that means.
I guess.
So, well, and you guys, did I tell you my joke about evidence? That literally, I didn't take evidence in law school because I didn't like Willie Janego, who was a professor at USC that taught evidence, and it wasn't a required course. So I'm like, sure, I'm not taking it. So I learned a lot about evidence when I was studying for the bar exam. Surprise, surprise. And later, 20 years later, after I've been a member of the bar for 19 years and practicing and all this, I became a judge. And I used to joke with the lawyers. I think I made this joke with you, Mr. Dolan, that I didn't take evidence. And no one is ever surprised, and I don't know why that is.
Actually, I was very surprised because there's a very subtlety. There's a deep subtlety in the evidence code, and he knew it. I
Yeah.
was trying to get away with a little something.
Yeah. Yes, he was.
And he no, can't do it. And I'm thinking, well, he can know why.
The funny thing about it is you can learn an awful lot about evidence by actually reading the rule.
Yeah, the rules are so simple. That's
And this, and if it's what I'm thinking it is, you actually read it, you go, oh yeah. And I'm always amazed that when at some point the evidence comes up during a trial. I haven't done a trial for a while, but I like get the evidence go. Sorry,
There it is right there.
And just reading the effing rule makes a big difference.
We want you to love your evidence.
Yes.
All right.
All right, see you later. So, I am still suffering from a stupid asthma. I did go to a specialist yesterday. He ordered more tests, more medication, and come back and see him on June 3rd. So, the good news is I'm not hacking all the time, but when I talk, I start hacking. So it's great. Thanks a lot. It's not like we don't need to talk. So here, by the way, Professor Nolan, working in San Francisco. Poor guy has to be in San Francisco. Except it really sucks because you're in a fun city with lots of great restaurants and stuff, and you're working all the time. But hey, you probably get good takeout. Anyway, I am informed to believe and they're on the ledge that he will be here next week. Next week, we're going to review the sample test. You guys all got that? Trish, you got that? Okay. So we will review the sample test and we will answer whatever questions you guys have as we get ready. You didn't hear from me, you didn't hear from me, you didn't hear from me. We're probably going to have 2 evidence questions and some multi-states, okay? But you didn't hear from me. Who didn't you hear from?
No, you're what?
Yeah, exactly.
I didn't hear it for real. I didn't hear it. What did you say?
I'm sorry you didn't hear from me. What I was saying is there's a vicious rumor going around that you'll have 2 evidence questions and some multi-states on evidence. And like I say, you didn't hear from me.
Huh. Okay. Thank you.
So who didn't you hear from, Trish?
I didn't hear anything from anybody.
So I think we had this last week, but Nolan sent it out yet again this week. And this is the summary of the whole effing course. I mean, the whole course, right? So we can go through this tonight as much as you want. If there are particular things you want to talk about, whatever you want to do, okay? I will be glad to go through and point out a few things that people generally screw up, if that would be helpful. Anyway, what do we think? Yeah, because this is a pretty good summary. It will at least remind you of what we've been talking about since last September. Okay, so let's go through and let me pick up a few things that I have noticed that people kind of screw up. First of all, know how Rule 403 works, right? You long ago should have had a really good rule statement on this, right? Does the probative value, is that substantially outweighed by the risk of unfair prejudice, undue consumption of time, confusing the jury? It can be more than one of those things. This is where some folks have gone astray on this. Is Rule 403 is what you might call a yay more rule, right? It's going to confuse the jury. And what's more, it's also going to take too much time. And what's more, it's going to cause unfair prejudice. It can be all of those things. You don't have to just pick one. So if you see a Rule 403 issue, and you will almost always see a Rule 403 issue, right? Because it tends to come up a lot. Don't box yourself into, I got to pick. You don't have to pick. It can be all 3 or 2 of the 3, and pick your strongest one, and then say, and what's more, it's So that's one place that folks generally get, or not generally, but sometimes get confused, is they think, well, I got to pick. You don't have to pick, but you do have to have that rule down, right? Substantially outweighed by, right? Probative value substantially outweighed. And what is probative value? How does it relate to relevance? Relevance is a yes, no, either it is or it isn't. Probative value is it is, and now it's how much, how black is it, how white is it, whatever you want to call it. All right, character evidence, very, very particular. And notice that the defendant gets to offer some things and then the prosecution responds. The defendant can offer evidence and then the prosecution responds. In a homicide case, again, the defendant has to raise an issue that the victim was a first aggressor, and then the prosecution gets to respond. witness's character, okay. And you can offer evidence of crimes or other bad acts for other reasons besides character. If you can come up with a reason, and the summary lists a whole bunch of reasons. So just because you can't, here's another spot that people sometimes get confused on. Just because you can't offer it as character doesn't mean it's the end of the road, right? You literally can get the same piece of evidence in for some other reason. It's not being on, okay, I can't get the specific act evidence in as character, but what can I do? I can get it in to show planning, intent, knowledge, all those kind of things. Identity. Generally, to prove identity, it's got to be a higher standard of proof, a lot closer to the circumstances of our case, lower similarity for other purposes. Identity, you've really got to be close, right? I mean, it's got to be like, yes, and the bomb had 3 twists and was done with red wire in this particular plan and all that kind of thing. All right. Okay. All right. Habit or routine practice. Remember, people have habits, businesses have routine practices, we acted in accordance with that. And we put, even if not corroborated or an eyewitness. Yep. So don't think that you got to have somebody else testify to it. Literally the guy who's saying, yeah, that's my habit, can testify to it. Subsequent remedial measures excluded not because it's not relevant, not because it's not probative, not because it's unduly prejudicial or anything else, but because we're trying to advance some other policy goals. What's the other policy goal? We want people to fix dangerous stuff, right? We don't want them to say, well, I would have fixed it, but I was afraid I might lose the lawsuit. So it's not admissible for certain purposes. It is admissible for other purposes. So know what you can use it for and what you can't use it for. Guide yourself accordingly. Similarly, we're going to exclude it for other policy reasons, offers to compromise and negotiations. But again, you can offer it for another purpose, right? Same thing for medical expenses. Plea negotiations, very specific rules that relate to those. But again, the basic idea is it's not that it's not relevant. It's not that it's unduly prejudicial and anything else. It is relevant. It is helpful. It's not unduly prejudicial, but we don't admit it because we want to further other policy goals. Kind of like privileges, right? Privileges take otherwise admissible, sometimes really powerful evidence and excludes it because we got other policy goals besides just the search for truth. Okay. Liability insurance, again, you can't admit it to prove negligence or other wrongful conduct, but you can admit it to show like ownership or something like that. All right, witness competency. Remember, experts don't have to have personal knowledge, right? They can testify based on assumed facts or what they've heard from others, as long as people in their business rely on other stuff. You do have to have an oath. Kids don't have to take that formal oath, but they do need to understand the idea of telling the truth and not lying. There are special rules about judges and jurors that literally never come into play ever. Because if you're a juror and you know something about the case, you don't end up on the jury, which is kind of funny because in the good old days, who were the jurors? The jurors were people from the community who did know about the case. Back in the 13th century, 14th century, 15th century in England. It's kind of funny how that's evolved. All right, cross-examination, rules about impeachment, character for truthfulness. You can always offer evidence of character for truthfulness, and remember, it's got to be reputation or opinion evidence, not specific act, right? But you only it's only admissible after someone attacks it. In other words, you don't get to like bolster your witness before someone suggested that he or she is not truthful. Specific instances, you can ask the witness, isn't it true that you cheated on cards or whatever? And if they say no, well, you're screwed on cross. Doesn't apply to criminal convictions. There you can offer extrinsic evidence proof of the conviction. All right. Criminal convictions, special rules about these, and it's sort of like a felony and sort of like a misdemeanor. Anyway, just know what the special rules are and the 10-year thing, because then it changes a bit. And of course, if you got pardoned or whatever, too bad, it doesn't count as a conviction. Juvenile adjudications only in a criminal case of a witness, not the defendant, and so on. If the case isn't final, there's an appeal pending, you still get to use it as long as there was a judgment. But the other side gets to say, and it's on appeal, right? Religious beliefs or opinions not admissible unless you're getting confirmed by the Senate to be a federal judge, in which case you can get raked over the coals on your religious beliefs for some reason. I don't know why. It does seem to be that way. Okay. Order of questioning a witness. Who goes first? The side that called the witness. Do they get to ask leading questions? Generally, no, unless the witness is what used to be called hostile. In other words, a witness who isn't trying to help out the person who called them as a witness. And a classic example of that in a civil case is my first witness in my plaintiff's case, the defendant, right? Put them on the witness stand. Can you ask leading questions then? Of course you can. That witness doesn't want to help you out. So just because you suggest an answer, man, the witness isn't going to be picking up on the suggestion. So generally, whoever calls the witness doesn't get to ask leading questions. But if the witness isn't being helpful or isn't trying to be helpful or has a reason to not want to be helpful, then you can ask leading questions. Usually you have to throw a few softballs and have the witness not treat them in the manner that you would like them to before you get to ask leading questions. You could also use that with kids or on foundational matters. It is an interesting tactic to let the other side get away with asking leading questions. And let's face it, it's way easier to ask leading questions, right? Because you know what you want the witness to say, so you just say the words and have them agree with it. Well, obviously that's less persuasive than the witness coming up with it themselves. But if you get in the habit of asking leading questions and the other side's not objecting, and then when you get to like the really crucial stuff and they object, and now the witness gets a little flustered because the witness is used to it. Yeah, that's right. And now they got to come up with an answer themselves. And of course, it makes you look at the crucial time like you're doing something wrong when that objection gets sustained. So if you're on the receiving end, sometimes let those leading questions go by until it really matters. And cross-examination is limited to the scope of direct examination. Recross limited to the scope of redirect, and so on. So in theory, you keep getting narrower and narrower and narrower until finally there's nothing left to ask about because everything's been covered. But the judge can allow you to go outside the scope of direct or cross or something like that. Lay witnesses. The key thing with lay witnesses is it's not based on scientific, technical, or other specialized knowledge, right? So you can't sneak someone who isn't an expert in and say, oh, I'm just asking for a lay opinion, right? If it really is an expert opinion, they don't get to offer an opinion unless they're actually qualified as an expert. Expert witnesses, they have to be qualified, but they can be by a whole bunch of ways, right? Knowledge, skill, experience, training, or education. So if they know about something that ordinary people don't know about, then they're an expert and they get to offer an expert opinion. Like Mona Lisa Vito, right? Wasn't that her name? In My Cousin Vinny, the girlfriend? Marissa Tomei. I think it was Mona Lisa Vito. And she, well, I'm sure your like father and brothers and cousins and all that are expert, but how are you? Well, and she showed them. And that's a great illustration of it doesn't matter how you got the knowledge, right? It could be that you hung out at your family's garage, but as long as you've got the knowledge, you can testify as an expert. And as long as the expert testimony will assist the trier of fact in determining an issue. And of course, you got to have sufficient facts or data. You don't get to just speculate. And must be the product of reliable principles and methods, and they've got to apply those principles and methods to the facts of the case. Notice that Daubert is different than the old Kelly-Frye standard that we still use in state court. It doesn't have to be generally accepted by people in the field as long as it's reliable principles and methods. So if you run into that, remember that distinction. Kelly-Frye is you're using methods that people in the field generally accept. With Daubert, it doesn't have to be generally accepted as long as it's reliable and you can convince the judge that it's reliable. Experts can use information that they know of or that people in their field generally rely on. Often what they do is, yes, I read the deposition transcripts, I went out to the scene, or my assistant did, and took some measurements, whatever. And so that's how I'm able to offer these opinions about how fast the cars were going and when one started to break and all that other good stuff. And of course, remember that you don't get to introduce facts that are significant to the case through the expert unless the expert actually knows them. So if you want to get in for the truth, the things that the expert read in the deposition or the things that the expert heard from someone, you've got to call someone who actually knows that. So for example, if you're going to call a gang expert, and that gang expert is going to say the defendant admitted he was a member of the Rolling 60s Crips when he was interviewed, you're going to have to call whoever interviewed him to get that fact in. The expert can rely on it and can say, yeah, I looked at notes from a field interview and I considered that in determining whether the defendant's a member of the gang and acted to promote, further assist the gang. That's great, but you're not going to get that admission in that I'm a member of the gang in unless you actually bring in the person that interviewed that person, or you've got some other admissible evidence of it, not just the expert saying, yeah, I'm aware of it. This was a significant change when our Supreme Court put that limit on it in it was called Sanchez. Ultimate issue, generally, you can testify as to the ultimate issue, except in a criminal case. In the criminal case, what's the ultimate issue? Guilty or not guilty, so you don't get to testify guys guilty. So, as an example, you may not be able to ask, did this defendant act in committing this bank robbery, did this defendant act to promote, further, or assist other gang members in criminal activity? And have the expert say, yes, this defendant did. Instead, you got to offer in the form of a hypothetical, assume that, and describe all the facts. Would it be your opinion? Do you have an opinion about whether the person who did this robbery under these circumstances was acting to promote, further, or assist, right? And you can see the rather subtle difference between I'm offering an opinion about what was in his head versus I'm offering an opinion based on these assumed facts about what would have been in somebody's head. The expert can say on direct, I considered this, I considered this, I considered this, but not like quoted, right? On cross, tell us specifically, what did you read? What did what in the deposition did you read? Okay, here's what I read. The other thing that you can't do on direct, you can't have the expert say, I've got a stack of books this high. All these other experts that wrote all these great books and see book, don't they look impressive? They all agree with you, right? And why is that? Because they're not on the witness stand and you don't get to cross-examine them. But on cross-examination, if the expert says, yes, I agree with Professor Nolan's book on whatever, then you can take Professor Nolan's book and say, really? Because you testified X, And here on page 317, Professor Nolan said not X, right? So how do you explain that, right? So on cross-examination, if they've said something is reliable, you can cross-examine them on that. Not on direct. You don't get to bolster the opinion by saying, yeah, well, the guy that wrote this really cool book, agrees with it. And then, of course, on redirect, what do you get to do? Well, explain. Yeah, that's what he said, but that's in a different situation, and he'd agree with me. Yeah.
Instead of as the witness saying that this person that wrote this book agrees with me, could you say that the opinion in the book that the person wrote is the same opinion as
No.
mine?
And the reason is that person's not in the witness stand, and so the other side can't cross-examine that person, right? You are in essence offering that person's opinion to, and you can't cross-examine.
Okay.
So you can say, right, I have read lots of literature, I've read lots of books, and I'm really familiar with everything in this field, but you don't get to say what all those books say, right? Unless it's inquired on cross-examination, and then of course, rule of completeness, you get to discuss it and explain why. Okay, courts can appoint experts, happens a lot in certain types of cases, not a lot in most cases. But like family law, some civil litigation occasionally, you get an expert. Okay, so hearsay, right? Anybody want to explain the hearsay rule to us? Come on, we all totally have this down. Trish, what's the hearsay rule? Yeah. Pause one moment.
I wanted to mute myself because sometimes it sounds, I guess, overwhelming.
Okay.
Hearsay is the statement. Hearsay is a statement, out of court statement, made by a declarant, offered for the truth of the matter asserted.
Okay, so how do we get around that if it's pretty clearly hearsay? One, it's not a statement by a declarant, right? It's a statement by a dog or a machine or something that's other than a person making a statement, right? So it's not a statement. Oh, it's not. It's made by a person, but it's not a statement. It's a question. It's not an assertion. It's a, whatever, but it's not a statement. It's not an assertion of fact. Okay? Or it is. I accept the offer, but it's got some significance other than the fact that you're offering it for the truth. It's got some legal significance, the fact that the words were spoken or the letter was written or whatever. So, okay, what about it's made by a party opponent, right? Sounds like hearsay, but we don't call it hearsay. Why? Because it's made by a party opponent. So literally the rules define it as not hearsay. And of course it could be a statement made by an authorized statement, a statement made by somebody in the, who's responsible for, what was our example about the guy who cleans the law school or whatever, et cetera, et cetera, et cetera, or an adoptive admission, something like that. Okay. And if you still can't get it in, well, is there an exception to the hearsay rule, right? And there's a ton of exceptions to the hearsay rule, and you should know it. All right. So when you're going through a hearsay statement, remember it can be something is being asserted without using words, right? Point. That can be an assertion. Conduct can assert something. As long as it's intended to be an assertion. A human has to be the declarant, right? It can't be a machine or a dog or something. It's a statement made other than with a witness on the witness stand, which means you can have the witness on the witness stand and ask them about something they told the police 6 months ago, and it's covered by the hearsay rule. But wait just a goddamn minute. How can that be? Because it's the witness on the witness stand, right? But you're not asking the witness on the witness stand about what they're saying from the witness stand. You're asking them about what they said on some other occasion, which means it is covered by the hearsay rule, and you either have to define it away as not hearsay or find an exception to get it in, right? This is a place where real lawyers make mistakes on this all the time. All the time. Because they're like, well, the witness is on the witness stand. Yes, but you're not asking them about what they said this morning or what they're saying right now. You're asking them about what they told the police 6 months ago. Okay? Everybody's got that, right? I know we talked about that to a ridiculous extent, but the reason we talked about it so much was real lawyers screw that up all the time. Okay? All right, so as we talked about, it's not hearsay because you're on the witness stand, you were subject to cross-examination, you made an inconsistent, it was testimony under penalty of perjury, or it was consistent and offered to rebut a charge of recent fabrication, improper influence or motive, or just because it's a statement of identity, right? Opposing party statement, it's not hearsay. Remember that these things are not hearsay because we call them that. And various statements adopted, made by the party, made by someone else that's going to bind the party. The tricky one, of course, is it was made by a co-conspirator during and in furtherance of the conspiracy. It's got to be during and in furtherance of the conspiracy. Okay? All right. And then 803, we've got hearsay exceptions that apply regardless of whether the witness is available. And of course, we went through all of these, and you can go through all of these. Remember the recorded recollection one, you don't get to put the written statement in or the tape recorded statement or whatever in, you get to read it. Okay? That was just a tweak on that because it's basically a substitute for the witness saying it from the witness stand.
Right, it doesn't become an exhibit, it just gets read in.
Right, exactly. Although as a practical matter, you're going to mark it as an exhibit, but it's not going to be received into evidence so that you know exactly what was read, right?
Right.
So you're probably going to mark it, it's just not going to be received. Okay. Then when a witness is unavailable, and know what a witness being unavailable means, and then there are exceptions. Okay. Former testimony given as a witness, offered against a party who had an opportunity and similar motive in questioning, under the belief of imminent death, and remember the state rule is slightly different. You got to die, not just believe you're going to die, but under the federal rules, you just believe you're going to die. Statement against interest. Sometimes it's not real clear that it's so contrary to the declarant's proprietary and pecuniary interest that it would expose him or her to criminal or civil liability. But if you got that, it's got to be supported by corroborating circumstances that clearly indicate trustworthiness or exposes the declarant to criminal liability. Family history and a statement offered against a party who wrongfully caused the declarant's unavailability. Okay, and remember, you got to have an exception or an exclusion or whatever for every level of hearsay. But it doesn't matter how many levels you got, right? As long as you can keep stacking up the exceptions, exclusions, whatever, you can keep going, right? But if you're doing a question on that, you got to analyze every level, right? And you're cool until you get to a red light, and then the whole thing fits. And so that means that some statements might be admissible and some might not. So you may be able to admit part of a hearsay statement, but not other parts, if that part includes maybe somebody else's hearsay statement that you don't have an exception or exclusion or something for. Credibility of the declarant can be attacked, right? The declarant is that person who's making the out of court statement, not the person on the witness stand. And you've got this great 807 catch-all, right? So if you think you're close and you just can't make it, don't forget about the catch-all. You say, look, this serves the purposes of the hearsay rule to make it reliable, and so you judge ought to admit it, even though it doesn't technically fit within one of the exceptions to the hearsay rule, which of course doesn't help you in a criminal case, right? Now we get to Crawford. Remember, and this is a real lawyer mistake in the real world. Crawford only applies to evidence offered by the prosecution in a criminal case. If it's not being offered by the prosecution in a criminal case, you don't have to worry about Crawford. But if it is, of course, it's got to be admissible both under Crawford and under the law of hearsay, right? So if it is evidence being offered by the prosecution in a criminal case, you have to do both analyses. Now, they may overlap a lot, right? But they're separate analyses and you have to do them both. So basically, Crawford, if it's testimonial, it doesn't come in unless the defendant has the opportunity to confront and cross-examine. But it doesn't have to be confront and cross-examination at this hearing. It could have been in a preliminary hearing or some other way. And as long as they had the chance, they didn't have to take advantage of it. As long as they had the chance, then Crawford's satisfied. And of course, do you ever get one that's like on an exam, do you ever get a clean Crawford thing where it's clearly testimonial? Of course not, right? We wouldn't do that to you. That would be too easy. So you're probably going to get something where there's arguments one way or the other that it's testimonial or it's not, right? And nobody knows what testimonial is, except it's pretty clearly where the police are gathering evidence to present at trial. Clearly, if the witness is like being examined by a grand jury or something. Not so much if it's made to somebody other than the police, a friend, a doctor, somebody who's trying to figure out, maybe it could be a police officer if they're trying to figure out, is there an emergency? Is this still going on? What the hell happened? Why is this person so bloody, right? So expect that if this is on one of your, this comes up in the exam, that you'll have arguments both ways about whether something's testimonial, right? But remember, if it's offered by the prosecution in a criminal case, it's got to meet Crawford and the law of hearsay. So whatever you do, analyze it under both, right? Because we want to know that you recognize there is a Crawford issue, even if you conclude there is no way on God's green earth this could ever be admissible hearsay. You should say, but if somehow it was, there's Crawford, and do the Crawford analysis. All right. Because we want to know that you recognize the Crawford problem and can analyze it. So if you get a Crawford problem, you got to do both the Crawford and the regular hearsay analysis. And it doesn't matter which order you do it in, right? We don't care, but you got to do both. And recognize you are always, always, always going to have what kind of analysis after you do Crawford and hearsay? 403, absolutely. So don't forget that, because you're like, oh man, first I had to figure out, oh yeah, it's a criminal case. Oh, it's in state court. Oh, Prop 8, right? Throw away. And then I had to do a Crawford analysis, and then I had to do the hearsay 403. So make sure you do all of those things. And of course, you're going to describe at the start why it's relevant, but hey, that's usually not a problem. Anyway, good summary of Crawford, Davis, Michigan versus Bryant, etc. Here. So, and we've got at the top of the page is the declarant unavailable? If not, hey, guess what? You don't have a Crawford problem. Put them on the witness stand. Right? Is it testimonial? Okay, yes, go to that. Has the defendant ever, right? So this is a pretty good summary of how you go through that. Privileges, know what they are, right? And again, privileges were like those things we talked about earlier, where it's relevant, maybe really highly probative, but for some policy reason, we're not going to admit it. And the policy reason usually is we want people to talk to their lawyers and be candid with them. or their doctors, or their priest, or their psychologist, or, right? We want husband and wives to be able to communicate with each other freely. So even though it would be really helpful, it's relevant and powerful, whatever, you don't get to use it. Remember, the spousal privilege has two parts to it, right? And they're distinctly different. One is you can't be compelled to testify about your spouse. The key in that is, are you married now? Right? If you are married now, you can't be compelled to take the witness stand against your spouse. It's sort of a slightly different version of the Fifth Amendment, right? If you want to think of it that way. The other part of the privilege is, were you married at the time that you made the statement or heard the statement, right? Because usually it's you hear something that the defendant says, right? If that's the case, then it's privileged and you can't be compelled to testify about it, even if you're not married now, right? So two different policy things. One is we don't want to screw up marriages by, having a husband or a wife get on the witness stand to testify against their spouse. The other is we want to encourage people to candidly talk to each other when they're married. And the key is, with the second, were you married when the statement was made? The key with the first is, are you married now when you're asked to testify? There is, of course, a crime fraud exception, so you can't go to a lawyer and get advice about how to commit a crime in the future. You can get all sorts of advice about how you already committed a crime and how you can defend against it, but you can't get advice about committing a crime in the future. All right. Okay. Authenticating evidence. Simply, you got to be able to show, if you're the proponent of the evidence, that it is what you say it is. And there's various examples. Certain things are self-authenticating, and be familiar with those. And of course, exhibits have to be relevant, meet 403, don't include evidence that would violate the opinion rule or inadmissible hearsay, and have to be authenticated. And again, somebody's got to tell us what it is and have a sufficient basis so we can say, yep, that is what you say it is. All right. Best evidence rule, what do we really call it? Secondary evidence rule, right? Or as we describe it, original writings rule. You've got to come up with the original or a copy, unless there's a dispute about the content of the original versus the copy. Okay, judicial notice, we talked about that 3 weeks ago, 2 weeks ago? 3 weeks ago. And what fun it is, remember, it's adjudicated facts, not legislative facts. Legislature can do whatever the hell they want in figuring out facts that they rely on. And it's got to be something that's generally known within the court's territorial jurisdiction or accurately and readily determined from sources whose accuracy cannot reasonably be questioned. All right, you can be creative on that. You can do it at any point. Court can do it on its own. You must take it must take judicial notice that the party requests it, and you're given the necessary information. The other side has to have an opportunity to be heard. And of course, the distinction between civil case, tell the jury you must accept this fact as true because I took judicial notice of it. Criminal case, jury, you get to decide whether it's true or not. I have taken judicial notice of it, but it's ultimately your decision. And presumption in civil cases, it's who's got to produce the evidence to rebut the presumption. And we got into the burden of producing evidence, the burden of proof, whatever. But it's basically a presumption says you got to go first with some evidence. All right. So, any questions about anything that we've covered during the entire year of the class? We will have next week, we will go over the practice exam and we will go over anything first semester, this semester, anything at all that isn't clear you want to discuss, anything. And hopefully I will be not hacking as much. I'm actually doing pretty well right now, which means when I stop, I'm going to start talking. I'm going to start hacking. Yes?
I know you did a little bit of Prop 8
I'm sorry?
Prop 8.
Prop 8, okay? Prop 8 comes up only is a state law. It says all relevant evidence is admissible, except it really doesn't mean it, because the Miranda rule applies, the hearsay rule applies, everything applies. So just say, in criminal cases, Prop 8 says it's all admissible, but we know that that's really not true. So just mention it and move on. It doesn't really affect analysis other than to say, Prop 8, state criminal case says all relevant evidence is admissible, but it doesn't really work that way in practice. And I only mention it because if you do have a state law criminal case, say so and move on and do the rest of the analysis like Prop 8 didn't exist. Trish, what's going on?
I'm just
Okay.
listening.
Okay. For the multi-state stuff, I don't know about our questions, but I can tell you the like folks that do the multi-state like all the little nuances of the rules of evidence to the extent they write questions about it. And so you'll probably get a couple answers that you go, well, that's completely wrong. And then there are two that are like sort of right, mostly right, and try to figure out which one is more right than the other is the challenge. But they tend to like to get into the, that 10-year thing on the admissibility of criminal convictions. Well, what if it was a juvenile case and over 10 years and and whatever, right? And there's no substitute for actually like remembering the rule. But again, on 403, it's almost always going to be in there somewhere. And you don't have to do it first, you don't have to do it last, just make sure you do it. And this is one of those areas where often there's not a right answer on 403, just like in the real world. Judges have a lot of discretion under it, may admit it, and the courts of appeal basically say, as long as we can tell that you, judge, knew that you had discretion to admit it or not under 403, and we can see that you weighed the various factors, you're good. So, and the same thing goes for you guys. When you're doing a 403 analysis, it's not important that you get it, that you come to the same answer that I or Professor Nolan would come to. It is important that we can tell that you recognize the rule, that you have a good rule statement, and that you did the balancing and had an explanation for why, after looking at the various factors, you came out the way you did.
After the midterm, I struggled certainly with multi-states on hearsay, particularly. Do you think because we didn't go over them, maybe next week we could spend a little bit of time going over a few of those? Because
Yeah, absolutely.
I think the problem with hearsay questions is I try to do like the whole analysis in my
Right,
head,
right.
and it takes forever.
Yeah.
And you're trying to do it in less than 2 minutes.
Right.
So.
Yeah, I will look for some examples we can talk about.
Okay, cool.
Yeah, absolutely. Anything else I should look for?
No, I think it was just like one question after another of, the hearsay questions, they have like 3 or 4 parties in each question.
Yeah,
Just trying to
no,
keep
it's
everybody
great.
straight.
Yeah, just trying to keep everybody straight.
Yeah, and then go to the next one, the same thing. Now it's
Yeah.
4 new parties and.
Right, yeah, thanks a lot.
Yeah.
Yeah, thank you, Bar Examiner. She really made this easy.
See, as you said earlier, that girls are usually better at the writing. That's not my case. I'm way worse at the multi-states. I'm way better at the writing.
Yeah, well, statistics are statistics, right?
Right.
There's a lot of variation.
There's a lot of stuff.
Yeah, exactly.
Yeah.
Exactly. So, okay, yeah, I will find some multi-state practice stuff on your side. Anything else we want to talk about this evening? So you guys know how to get a hold of us. Nolan, I understand, will respond to emails. He's not that busy, and I certainly will. If you haven't heard from me in like 12 hours, Send it to me again, because it probably got lost in a bunch of other emails. I literally yesterday morning, I'm like, oh my God, because my lawyer, my divorce case, had emailed me on Friday about something, and I was like, oh crap, how did I not see that one? That's kind of important. So if you haven't heard back from me in like 12 hours, send it to me again. Mark it high importance or something. Or use Tekla's name, and then I'll definitely get back. Yeah, it was basically, I have to leave. Can I talk to you on Monday? And I'm like, oh, well, yes, you can. Yes.
Wasn't there something about, we can't bring up somebody's, I can't find it, the past criminal conviction?
Yeah, there are rules about using convictions, right? Look on the bottom of, I guess it'd been page 3, right? FRE 607 to 611, cross-examination and impeachment. 609, criminal convictions, and it's pretty specific, right? And then there's the after 10 years, things change, and you've got that weird reformulation of 403, where the probative value substantially outweighs the prejudicial effect. Wait a minute, that's backwards. Yeah, it is, but that's what the rule is, okay? And notice, and so, yeah, 609.
Okay.
So yes, you can do that. You can use a criminal conviction. But watch for the, what about a criminal conviction in a juvenile case? Can't use a criminal conviction of the juvenile, could use it for a witness. You know, it's a, and like I say, that reverse the Rule 403 standard, it's easy to get mixed up on that, right? Because it sounds the same, but it's not the same at all. Instead of the probative value being substantially outweighed by the prejudicial effect, it's the other way around, right? The probative value substantially outweighs the prejudice. What? You know, it sounds the same, but it's not.
Good.
All right. So you know how to get a hold of me, right? And Nolan. Okay. So give it your best shot on that practice exam, because the harder you work on it, the more you treat it like a real exam, the more you get out of it. And we will go over it next week. Okay. And I will look for multi-stage. Oh yeah, I can read that, sure.
I always say
Trish, anything for you?
The other thing I thought, are we turning those practice exams in, like by email, or just going over them next week?
Email them if you want us to give you specific comments, otherwise we'll just go over it.
Okay.
So, be helpful. You'll get the most out of it if you send it to us beforehand.
Okay. Thank you.
You got it? Okay. Thanks, everybody, and good luck. We'll see you next week.
Thank you.